prayer.
Would you bow with me? Dear Father, again, thank you for all the wonderful blessings of life. Father, let us never forget not only this Christmas, but every day of our lives that you gave this world the greatest gift of all when you allowed your son Jesus to be born as a human being, to live on earth as a human, to experience what we experience. But most of all, thank you, Father, for allowing him to live a perfect life unlike us. Father, thank you for allowing him to live a sinless life, the examples he set for us. Father, let us never forget you loved us so much that you allowed him to die for our sins. Thank you, Father, for raising him from the dead. Father, please be with this county tonight. Everybody here tonight, Father, let us always remember, Father, that we're all your children. Father, let us learn to love each other, not to hate anyone. Father, let us, whatever's in our hearts, be known to man rather than just have it on our lips. Father, please go with us and bless us. Give us guidance. Give us strength to do what's right for the people of our county. We love you and your son Jesus, for it's in his name we pray. Amen. Amen.
First thing you see on your agenda, accepting the minutes of the last court meeting, we have those.
December 7th and December 10th.
Motion.
Got a motion and a second. All in favor?
Second. Yes.
Next thing you see is a resolution for the 2015 tax rate. This includes everybody's rate. A resolution relating to the levy and adoption of tax rates for Martin County and the approval and acceptance of the tax rate for special districts and other taxing districts. Whereas the Martin County Fiscal Court on December the 17th determined the tax rates necessary to produce sufficient revenues for operation of county government and services. Now therefore it be resolved as follows. Section 1. There is levied for the 2015 general and Val-Owen tax rates per $100 of assessed value of all taxable property within Martin County Fiscal Court as follows. A. Real estate, 11.5 cents per 100. Tangible, 14.5 per 100. Motor vehicle, 14.5 per 100. Section 2. The Martin County Fiscal Court hereby accepts the tax rates per 100 sets of valuation as set forth below for each special district or other taxing district. The Health Department, 4.0 across the board. The library, 10.9 for real estate and personal and vehicles, 4.5. Extension office, 4.8. Personal, 9.09. And vehicle, 2.2. The school board, 76.1. Personal, 76.1. Vehicle, 22.3. Section 3. This resolution be published in the Mountain Citizen within 30 days after adoption. Section 4. Prior to making expenditures which have not been previously budgeted for under anticipated income, the budget for the fiscal year 2015 and 16 shall be amended by KRS 6820280. Section 5. This resolution shall become effective upon adoption this 17th day, December 2015. Motion.
Motion.
Second.
Second.
All in favor?
Yes. Need to go ahead, Kelly. Library dropped 2 rates a little bit this year.
Yeah. Second reading of the FAR ordinance. Rhonda, if you'll read that.
An ordinance relating to the addition of volunteer fire department annual subscriber fees to the property tax bills of property owners in Martin County, Kentucky. Whereas pursuant to KRS 75450, the Fiscal Court is allowed to adopt an ordinance requiring the annual subscriber fees to be added to the property tax bills. And whereas it is the desire of Martin County Fiscal Court to better equip and train the volunteer fire departments, and whereas Martin County Fiscal Court believes it is in the best interest of the 6 volunteer fire departments located within Martin County to adopt this ordinance, therefore be it hereby ordained by the Fiscal Court of Martin County, Kentucky, the subscriber fees of the 6 local fire departments shall be placed on the tax bills for collection. Section 1, definitions. For the purpose of the ordinance, the following terms shall be deemed to have the meaning indicated below. District refers to 6 volunteer fire departments located within Martin County, Kentucky. Property owner. A property owner is an individual who owns a tract of real estate within the geographical limits of Martin County, Kentucky. Subscriber fees, fees which are levied by a volunteer fire department in order to provide fire protection services for a tract of land in lieu of assessing a charge for fire protection services actually performed. Section 2, collection and enforcement. For the purpose of this ordinance, the following duties shall be established and the fees shall be collected as follows. A, Martin County Clerk's Office shall have the duty of placing the subscriber fees upon the property tax bills on properties located within Martin County. The subscriber fees shall be separate from taxes owed so as to allow the property owner to ascertain the amount owed. B, Martin County Sheriff shall have the duty of collecting the subscriber fees while collecting all taxes listed on the property tax bill. Upon collection, Martin County Sheriff has the duty then to distribute the collected fees to the 6 volunteer fire departments. Martin County Sheriff shall distribute the funds to the district in which the property is located. Section 3, subscriber fees. The following subscriber fees shall be in place upon adoption of this ordinance. Property owner fees. Subscription fees as established annually by each volunteer fire department district shall be added to the property tax bill of every property owner as to each tract of real estate located within Martin County, Kentucky. Subscriber fees may not exceed $30 per parcel. Establishment of fire district fees. Every volunteer fire department shall certify to the Martin County Clerk in writing no later than July 1st of each year the amount of the subscriber fees for each respective district. In the event a fire department fails to certify the annual fees of the fire district, the fees for that fire district shall remain the same as the prior year, and the county clerk's office shall rely upon same in the printing of the property tax bills. Requirements regarding subscriber fees. All fees referenced herein shall not be seen as mandatory. Each taxpayer owning real estate, however, will be required to pay the fees at the time the tax bill is paid. The Martin County Sheriff cannot accept partial payment for taxes, and thus this amount must be paid at the time all taxes are paid to the sheriff. Subscriber opt-out procedure. Any subscriber subject to the fees imposed by a volunteer fire department in any area described in this ordinance shall have the right to petition the fiscal court and opt out of the volunteer fire department subscriber fees placed on the property tax bill. This is to also include those being homestead exempt, property being assessed at $31,400 or less. Those subscribers wishing to opt out shall file a petition with the fiscal court between April 1st and June 1st of the year preceding the issuance of the property tax bills. This procedure must be repeated each year by those wishing to continue to opt out. These forms may be picked up and returned to the Martin County Court Clerk during normal operating hours. The opt-out petition shall include the following: the name of the petitioner, the name of the volunteer fire department, an address or description of the real property being opted out. Any and all persons who decide to opt out of this ordinance and not pay the fire fees that were mailed to them and to whom emergency services are given on their property will be subject to the fees of KRS 75450. Penalties and interest. Pursuant to KRS 75450, any non-paid fees shall bear the same penalties and interest as state and county taxes. If, however, the property owner, business owner, or landowner pays the property tax in advance, the fees will be also discounted at the same rate. Failure to pay. Should a property owner, business owner, or landowner fail to pay their property taxes and subscriber fees, actions will be taken pursuant to KRS 75450. In order to prevent these actions from being taken against the property owner, business owner, or landowner must pay the property tax as well as the subscriber fee. As stated previously in this section, should the property owner, business owner, or landowner wish to opt out and not become a member of the volunteer fire department district, they must opt out prior to the property tax bill being generated by the county clerk. Otherwise, all subscriber fees will be due and payable at the time the property tax bill is due. Maximum fee required of landowners. If a landowner owns more than one property within the county limits, the landowner shall not be required to pay more than the equivalent of 3 residential fees. This requirement assumes that the landowner is opting in the membership. If the landowner wishes to opt out of the membership, he or she shall not be required to pay any fees to the local volunteer fire departments. However, he or she may incur the statutory allowed fees for non-member runs. Section 4, establish procedures for managing money. Each department shall comply with the following requirements. Audit. The volunteer fire department shall be responsible for auditing the funds collected yearly and report the findings to the Martin Fiscal Court for review. Savings. The volunteer fire department shall budget to keep 5% as a savings mechanism. Accounting. The volunteer fire department shall provide a detailed accounting to the Martin County Fiscal Court on a quarterly basis. Said accounting shall show all deposits made, including the source of each deposit. Further, the accounting shall show each check dispersed, including the check number, amount, to whom the check was written, and information concerning the reason said check was dispersed. This ordinance shall take effect and be in full force from and after its passage, publication, and recording according to law. Presented for first reading on 12/7/15, passed and adopted at the second reading on 12/17/15.
End of story.
End of story.
Motion.
Motion.
Second.
Second.
All in favor?
Yes.
Second reading 911 ordinance.
Okay, vote. 5-0. Is that correct?
An ordinance of the Martin County Fiscal Court establishing a service fee for next generation 911 emergency dispatch services to owners of real property in Martin County, Kentucky. Whereas Martin County Fiscal Court, as a function of the state government and pursuant to KRS 67083, enjoys the authority and necessary latitude and flexibility to provide and finance various governmental services within broad functional areas specified in the statute. And whereas the establishment, maintenance, and operation of Martin County 911 Dispatch Center is an essential public service, safety service, used by residents of Martin County as well as workers and travelers while situated in the county. And whereas Martin County Fiscal Court has determined that the current 911 service fee, $1 per phone line, as imposed by the county, is inadequate to continue to provide reliable, quality emergency communication services due to the replacement of telephone lines by wireless telephones and other technologies. And whereas Martin County Fiscal Court has determined that KRS 65760 provides for alternative methods of funding the operation of next generation 911 emergency services. And whereas Martin County Fiscal Court has determined that a 911 service fee imposed on each individual residential unit and each individual commercial unit will result in a more fair distribution of the burden of funding this service and create a more stable funding source. And whereas the 911 service fee imposed on residential and commercial units is intended to replace the current 911 service fee on telephone lines. And whereas the 911 service fee imposed on residential and commercial units will generate approximately the same revenue that was projected to be received from the telephone lines fees, thus being revenue neutral. And whereas Martin County Fiscal Court has the authority to set penalties for the failure to abide by the terms of this ordinance. Now therefore be it ordained by the Fiscal Court of Martin County that the new 911 ordinance shall read as follows. A 911 service fee shall be defined as an annual fee of $75 imposed upon each occupied individual residential unit and each occupied individual commercial unit located upon each parcel of real property located in the county of Martin, as determined from the records of the Martin County Property Valuation Administrator's Office. A residential unit shall be defined as a principal residential space occupied or designed for occupancy for residential purposes. A commercial unit shall be defined as a principal non-residential building space of any size occupied or designed for occupancy by an individual non-residential business or public-private enterprise. A unit occupied as of January 1st shall be deemed occupied. A unit not occupied as of January 1st shall be deemed not occupied and shall not be subject to 911 service. The 911 service fees collected shall be used for the delivery of next generation 911 emergency telephone service as provided for by KRS 65760. The 911 service fee shall be placed upon the Martin County ad valorem property tax bills prepared by the Martin County Clerk pursuant to KRS 133220 for the year beginning January 1st, 2016 and continuing every year thereafter. For the year beginning 2015 only, owners of all occupied rental units shall be eligible to claim a credit of $37.50 per unit against the annual fee due. This credit, which is the equivalent of a 6-month share of the fee, is granted to allow owners of rental property additional time to fully recover the amount of the fee from tenants. In subsequent years, the full amount of the annual 911 service fee shall be paid for all occupied units. The Fiscal Court shall, by resolution, appoint an appeals board to consider and resolve any claims of incorrect determination of occupied individual residential units or occupied individual commercial units. A 911 service fee shall be collected by the Martin County Sheriff and transferred to the Martin County 911 Dispatch Center on a timely basis as determined by the Judge Executive pursuant to executive order. The failure of any real property owner to pay 911 service fee as set forth in this chapter shall be punishable as a Class A misdemeanor. The provisions of this ordinance are severable, and the invalidity of any provision of this ordinance shall not affect the validity of any other provision thereof. And such other provisions shall remain in full force and effect as long as they remain valid in the absence of those provisions determined to be invalid. This ordinance shall take effect and be in full force from and after its passage, publication, and recording according to law. presented for first reading on 12/7/15, passed and adopted at the second reading on 12/17/15.
Motion. Motion.
Motion.
Second. All in favor?
Yes. No.
Now, the next one's a biggie. Rhonda, do you want help from,
My eyes are
do you want help from some of the matters on the reading? It's 25 pages. Okay.
Victor's good at that.
Victor, you want to start it out and
You
read
go
it?
5 pages.
Come on. See how good you teach school.
I don't mind helping.
Can't read.
I'd like Ken to start it out, and then Victor and Josh, and
We'll share it, I guess.
then Rhonda.
An ordinance regulating solid waste management, storage, collection, transportation, process, and disposal. Martin County's Fiscal Court ordinance number that will be put in later. An ordinance pertaining to the public health, safety, and welfare. Districts, franchise, collections, processing, transportation, and disposal of solid waste, providing a penalty for the violation of the provisions of this ordinance and repealing any and all ordinance in conflict herewith. Pursuant to the Kentucky Revised Statutes 224 and 109 and related administrative regulations, Martin County, including its cities, is designated as a solid waste management area based upon a solid waste management plan approved by the Energy and Environmental Cabinet, hereinafter referred to as the Cabinet of the State of Kentucky. In addition, Martin County is acting under powers outlined in KRS 67083, subsection 30, for which provides the authority for the exclusive management of solid waste by ordinance or contract. KRS 67083, subsection 3, subsections C and R, which provide authority to regulate the management, public sanitation, and garbage disposal service. KRS 67.0833H, which gives authority to fiscal courts for conservation, preservation, and enhancement of natural resources, and KRS 68178, which grants counties authority to license off-site waste management facilities. Now therefore be it ordained by the Martin County Fiscal Court, Martin County, Kentucky, that the ordinance shall be known as the Solid Waste Management Ordinance. The Fiscal Court or its designee shall be responsible for the administrative management of this ordinance and the promulgation of rules and regulations authorized in Section 7. Definitions. For the purpose of this ordinance, the following terms shall be deemed to have the meaning indicated below. Agriculture waste, any non-hazardous waste resulting from the production, processing of on-the-farm agricultural products, including manures, prunings, and crop residue. Approved incinerator. An incinerator that complies with all the current regulations of the responsible local, state, and federal air pollution control agencies. Bulky waste. Non-putrescible, solid waste consisting of combustible or non-combustible waste material from dwelling units, commercial, industrial, institution, or agriculture establishments which are either too large or too heavy to be safely and conveniently loaded into solid waste transportation vehicles. Cabinet is the Energy and Environmental Cabinet. Closure. The time at which a waste treatment, storage, or disposal facility permanently ceases to accept waste and includes those actions taken by the owner or the operator of the facility to prepare the site for post-closure monitoring and maintenance or to make it suitable for other use. Collection. The removal of solid waste from the designated pickup location to the transfer vehicle. Acceptable collection practices shall consist of door-to-door household collection. Collection box is an unstaffed receptacle utilized to collect municipal solid waste, commercial solid waste. All types of solid waste generated by apartment buildings, hotels, motels, stores, offices, restaurants, warehouse, or other service or non-manufacturing activities, excluding household and industrial solid waste. Compost, solid waste which has undergone biological decomposition of organic matter being disinfected using composting or similar technologies, being stabilized to a degree which is potentially beneficial to plant growth and which is approved for use or sale as a soil amendment, artificial topsoil, growing medium amendment, or other similar uses. Composting, the process by which biological decomposition or organic solid waste is carried out under controlled aerobic, am I saying that right?
Aerobic.
Can't say it. Aerobic, that's what I thought, but I want to make sure. And which stabilize the organic fraction into a material which can easily and safely be stored, handled, or used in an environmentally accepted manner. Composting may include a process that creates an anaerobic zone within the composting material. Composting does not include simple exposure of solid waste under uncontrolled conditions resulting in natural decay. Convention center, facility staffed during operating hours for the collection, substance, transportation of municipal solid waste. Coordinator, solid waste management program of the county shall be the county judge executive unless another is so designated by the Martin County Fiscal Court. County is the county of Martin County. Demolition and construction waste, materials resulting from the construction or destruction of residential, industrial, or commercial structures. Disposal, the discharge, deposit, injection, dumping, spilling, leaking, or placing of any solid waste or hazardous waste into or on any land or water so that such solid waste or hazardous waste or any constituent thereof may enter the environment, be emitted into the air, or discharged in any water, including groundwater. Disposable solid waste containers, a disposable plastic or paper sack with a capacity of 10 to 35 gallons, specifically designed for storage of solid waste. Dwelling units, any room or group of rooms located within a structure and forming a single habitable unit with facilities which are used or intended to be used for living, sleeping, cooking, or eating. Generator, any person by site whose act or process produces waste. Governing body, a county, a waste management district, an entity created pursuant to Interlocal Cooperation Act, a taxing district created pursuant to the provisions of KRS 180 through 65-192, a special district created pursuant to the provisions of KRS 160 through KRS 65.176, or counties acting under contract pursuant to KRS 109.082. Hazardous waste, any waste or combination of waste which are, because of its quantity, concentration, or physical, chemical, and infectious characteristics, may cause or significantly contribute to an increase in mortality, increase in serious, irreversible, or incapacitating irreversible illness, or pose a substantial present or potential hazard to human health or the environment when improperly treated, stored, transported, or disposed of, or otherwise managed. Household solid waste including garbage and trash generated by single-family residents, ranger stations, cruise quarters, recreational areas such as picnic areas, parks, and campgrounds. Industrial solid waste generated by manufacturing or industrial process that is not a hazardous waste or special waste as designated by KRS 224.868, including but not limited to waste resulting from the following manufacturing process: electrical power, generators, fertilizer, agricultural chemicals, food and related products or byproducts, non-ferrous metal manufacturing, foundries, organic chemicals, plastic and resins, manufacturing pulp, paper industry, rubber, miscellaneous plastic products, stone, glass, clay or concrete products, textile manufacturing, transportation equipment, and water treatment. Now, Mr. Sloan.
You're supposed to take 5 pages, Ken.
Well, I took 4 and something.
Key personnel.
Oh, dear God.
Key personnel, an officer, partner, director, manager, or shareholder of 5% or more of stock or financial interest in a corporation, partnership, or association, or parent subsidiary of an affiliate corporation or its officers. Directors, shareholders of 5% or more of stock or financial interest. Materials recovery facility, a solid waste management facility that provides the extraction from solid waste recyclable material suitable for the use of fuel, soil amendment, or any combination of those materials. Multi-family residential unit, a housing facility containing more than one dwelling unit under one roof. Municipal solid waste disposal facility, any type of solid waste site or facility where the final disposition of any amount of municipal solid waste occurs, whether or not mixed with or including other waste allowed under Subtitle D of the Federal Resource Conservation or Recovery Act of 1976, as amended, and includes but is not limited to incinerators or waste-to-energy facilities that burn municipal waste and contain the residential landfills, but does not include a waste site or facility which is operated exclusively by a solid waste generator or property owned by the solid waste generator, which accepts only industrial solid waste from the solid waste generator, or industrial solid waste generated to another facility owned and operated by the generator, who wholly owned subsidiary or medical waste incinerator, which is owned, operated, and located on the property of a hospital, university, which is regulated by the cabinet and used for the purpose of treatment prior to landfill of medical waste received from the generator exclusively or in combination with medical waste generated by professionals or facilities licensed or regulated to operate by the Commonwealth. That was municipal solid waste disposal facility. Municipal solid waste reduction, source reduction, waste minimization, reuse, recycling, composting, and materials recovery. Occupant, any persons who alone or jointly or severally with others who shall be in actual possession of any dwelling unit or any other improved real property, either as an owner or as a tenant. Open burning, burning of any manner in such burning of any matter in such a manner that the combustion resulting from burning is emitted directly into the outdoor atmosphere without passing through a stack or a chimney. Open dump, any facility on site for the disposal of solid waste which does not have a valid permit issued by the cabinet or does not meet the environmental performance standards established under regulation promulgated by the cabinet. Person, an individual, trust, firm, joint stock company, corporation, including a government corporation, partnership, association, federal agency, state agency, city, commission, political subdivision of the state of Kentucky, or interstate body. Processing, incinerating, composting, baling, shredding, salvaging, compacting. Let me say that again. Processing, incinerating, composting, baling, shredding, salvaging, compacting, or other processes whereby solid waste characteristics are modified or solid waste quantity is reduced. Public nuisance, illegal waste disposal practices that include but are not limited to open burning, open dumps, or littering, which are deemed to be a nuisance under applicable law. Recovered material, those materials including but not limited to compost, which have known current use, reuse or recycling potential, which can be feasibly used, reused or recycled, and which have been diverted or removed from the solid waste stream for sale. Use, reuse, or recycling, whether or not permitted, subsequent separation and processing, but does not include materials diverted or removed for purposes of energy recovery or combustion except refuse-derived fuel, RDF, which shall be created as a recovered material in an amount equal to the percentage of that received on a daily basis at the processing facility and processed into RDF, but not to exceed 15% of the total amount of municipal solid waste received at the processing facility on a daily basis. Recovered material processing facility, a facility engaged solely in the storage, processing, and resale or reuse of recovered material, but does not mean a solid waste management facility if solid waste generated by a recovered material processing facility is managed pursuant to KRS Chapter 224 and administrative regulations adopted by the Cabinet. Recycling. Any process by which materials which would otherwise become solid waste are collected, separated or processed and reused or returned to use in the form of raw materials or products, including refuse-derived fuel, which processed or when processed in accordance with administrative regulations established by the Cabinet, does not include the incineration or combustion of materials for the recovery of energy. Refuse-derived fuel, a sized processed fuel product derived from the extensive separation of municipal waste, which includes the extraction and recoverable materials for recycling and the removal of non-processables such as dirt and gravel prior to processing the balance of the municipal solid waste into the refuse-derived fuel product. Residential dwelling unit, a building or portion thereof providing complete housekeeping facilities for one person or one family. Residential solid waste resulting from the maintenance of dwelling units. Sanitary landfill, a permitted facility for the disposal of solid waste that companies with the environmental performance standard specified in 401 KAR 47.030. Sludge, any solid, semi-solid, or liquid waste generated from a municipal, commercial, industrial wastewater treatment plant, water supply treatment plant, or air pollution control facility exclusive of the treated effluent from a wastewater treatment plant or any other such waste having similar characteristics and effects. Solid waste, any garbage, refuge, sludge, or other discarded materials, including solid, liquid, semi-solid, contain gaseous materials resulting from industrial, commercial, or mining, excluding coal mining waste, coal mining byproducts, refuge, and overburden, agricultural operation, and from community activities, but does not include those material, including but not limited to sand, soil, rock, gravel, or bridge debris extracted as part of a public road construction project funded wholly or in part with state funds. Recovered material, special waste designated by KRS 224.868, solid or dissolved materials in domestic sewage, manure, crops, crop residue, or a combination thereof, which are placed on the soil or returned to the soil as fertilizer or soil conditioners, or solid or dissolved materials in irrigation, return flows, or industrial discharges, which are point sources subject to permits under Section 402 of the Federal Water Pollution Control Act. As amended, 86 Stat 880.
Statute Book 86.
Statute book, okay. Or source, special nuclear or byproduct material as defined by the Atomic Energy Act of 1954 as amended by Statute 68-923. Correct? Solid waste management, the administration of solid waste activities, collection, storage, transportation, transfer, processing, treatment, and disposal, which shall be in accordance with a cabinet-approved county or multi-county solid waste management plan. Excuse me. Solid waste management area or area. Any geographical area established or designated by the cabinet in accordance with the provisions of Senate Bill 2. Solid waste management facility. Any facility for collection, storage, transportation, transfer, processing, treatment, or disposal of solid waste, whether such facility is associated with facilities generating such waste or others, but does not include a container located on the property where solid waste is generated and which is solely for the purpose of collection and temporary storage of that solid waste prior to off-site disposal, or a recovered material processing facility in which, subject to regulation pursuant Senate Bill 2 for control of environmental impacts to prevent any public nuisance. Solid Waste Management Plan. The document submitted by solid waste management districts, counties, or any combination thereof as required under KRS 224.887 and approved by the Cabinet. Solid waste site or facility. Any place at which solid waste is managed, stored, treated, processed, or disposed. Solid waste storage container. Receptacles used by any person to store solid waste during the interval between solid waste generation and collection. Made out of plastic, vinyl, metal, ranging in size from about 10 gallons to 42 cubic yards in size. Storage. The containment of waste either on a temporary basis or for a period of years in such a manner as not to constitute disposal of such wastes. Transfer. The placement of solid waste from smaller collection vehicles into larger vehicles for transportation to immediate or final disposal facilities. Transportation. Any off-site movement of waste by any mode and by any loading, unloading, or storage incidental thereof. Treatment. Any method, technique, or process including neutralization designed to change the physical, chemical, or biological character or composition of any waste so as to neutralize such waste or so as to render such waste non-hazardous, safer for transport, amendable for recovery, amendable for storage, or reduced in volume. Also includes any activities or processing designed to change the form, to change the physical form or the chemical composition of hazardous waste so as to render it non-hazardous. Waste Management District. Any county or group of counties electing to form under the provision of KRS Chapter 109 and operate in conformance with the provisions of KRS Chapter 109 with Section 4006, Resource Conservation and Recovery Act of 1976, as amended by Public Law 94-580. Waste site or facility. Any place where waste is managed, processed, or disposed of by incineration, landfilling, or any other method, but does not include a container located on the property where solid waste is generated and which is used solely for the purpose of collection. Which is used solely for the purpose of collection and temporary storage of that solid waste prior to off-site disposal or a recovered material processing facility or the combustion of processed waste in a utility boiler. Yard waste, grass clippings, leaves, and tree trimmings. Section 2, storage of solid waste. Section 2(1), storage containers required. Storage containers for residential solid waste are required if bags of garbage are subject to be torn or damaged by animals or otherwise would create spillage and litter. Storage of waste shall be maintained in a clean, neat, and sanitary condition at all times. The containers and their contents must not weigh more than 50 pounds and be configured with handles for ease of handling by one person. The solid waste hauler will have authority to approve or disapprove questionable containers for storage frames. Oil drums will be accepted for storage of bags only and must have drain holes. Section 2(2), commercial storage. Containers for commercial waste generators will be provided by the solid waste hauler so as to be compatible with machinery for collection processes. They shall be maintained in a suitable manner by the commercial waste generator to ensure clean and sanitary conditions. The cost of the containers to the solid waste hauler can be recouped through rental charges to the generator. Section 2.3, standards for residential, commercial, institutional, and industrial use storage containers. All use which generates more than a volume of 2 cubic yards, approximately the equivalent of 500 pounds, or a quarter ton, or 400 gallons of solid waste per week shall be required to provide bulk containers for storage so as to be compatible with collection equipment and approved by the coordinator. The container shall be waterproof, leak-proof, and shall be covered at all times except when disposing waste therein or removing the contents thereof, and shall meet all requirements as referenced in Section 8. The cost can be recouped through rental charges to the generator. Section 2.4, airtight containers. No owner, occupant, tenant, or leasee of any building or dwelling may leave outside the dwelling or building in a place accessible particularly to children any abandoned or unattended white goods, including icebox, refrigerators, or other receptacles that has an airtight door without first removing the door. Section 2.5, storage containers not in compliance. Solid waste containers which do not meet the specifications as outlined in this action shall be considered waste and may be collected together with their contents and disposed of.
You want someone else give you a drink?
You want to take over, John?
Yeah. Section 3, collection of solid waste. Section 3.1, county responsibility defined. The county shall provide for the collection of all solid waste generated in the county, provided, however, the county may provide the collection service by contracting with a person, county, or other city, or a combination thereof, for the entire county or portions thereof as deemed to be in the best interest of the county. Section 3.2, mandatory collection. All generators of solid waste in Martin County shall utilize the collection program provided by the county. Section 3.3, collection points. Points of collection of solid waste shall be from the roadside or curbside within public right-of-way or other locations near buildings, parking lots, etc., on private property. In general, solid waste generated and stored in disposable containers shall be placed along the roadside or curbside fronting the subject property not more than 12 hours before collection. Residential, commercial, institutional, and industrial uses required to provide bulk storage containers shall be located on private property in areas accessible to collection vehicles. In the event that there are residences inaccessible to collection vehicles, as determined by the coordinator, alternative collection points may be arranged. Section 3.4, bulky items and heavy items. Items too bulky or heavy to put in storage containers will be collected upon request and as feasible if arrangements are made with the solid waste hauler, provided that the items are of a physical description compatible with conventional collection equipment. Bulky items will be subject to a separate charge because of the special handling and equipment required. Section 3.5, authority for collectors to enter private property. Solid waste collectors employed by the county or solid waste collection agency operating under contract with the county are hereby authorized to enter upon private property for the purpose of collecting solid waste as required by this ordinance. Solid waste collectors shall not enter dwelling units or other residential buildings for the purpose of collecting residential solid waste. Commercial solid waste may be removed from within commercial establishments upon written request of the owner and approved by the coordinator. Section 3.6, collection frequency. All solid waste other than bulky waste shall be collected at least once weekly. Residential, commercial, institutional, and industrial uses generating large quantities of solid waste may be required to provide collection at more frequent intervals, i.e. twice weekly or more. Upon Upon determination by the coordinator as necessary for the protection of public health, safety, and welfare, all collections shall be made between 6 a.m. and 6 p.m. Section 3.7, ownership of solid waste. All waste and refuse placed for collection shall remain the property of the waste generator, whether it be residential or commercial, until such time as the waste is placed in the collection vehicles. No person shall be allowed to separate, carry off, or dispose of waste and refuse placed for collection, and it will be a violation of this ordinance to do so. Section 3.8, collector's responsibility defined. Solid waste collectors operating within the county shall be responsible for collection of solid waste from collection points to a transportation vehicle, provided solid waste is stored in compliance with provisions set forth in this ordinance. Spillage or blowing litter caused as a result of the duties of the solid waste collector shall be collected and placed in the transportation vehicle by the collector. Spillage not caused by the collector is the responsibility of the waste generator. The waste generator shall collect and locate spillage at the collection point for the next scheduled pickup. Section 3.10, prohibitions. The following waste may not be deposited in solid waste containers or receptacles. 1. Hazardous waste. 2. Liquid waste. 3. Bulky waste, major appliances, furniture. 4. Tires. 5. Construction and demolition waste. 6. Dead animals. 7. Any burning or smoldering materials or any other materials that would create a fire hazard. 8. Batteries. 9. Any other items designated by the cabinet not proper for solid waste landfills. No unauthorized person may remove any item from a solid waste receptacle, climb on or into a container or receptacle, or damage any container. Section 4, transportation of solid waste. Section 4.1, collection vehicle standards. All commercial transportation vehicles shall be maintained in a safe, clean, and sanitary condition, and shall be so constructed, maintained, and operated as to prevent spillage of solid waste. All vehicles to be used for transportation of solid waste shall be constructed with watertight bodies and with covers which shall be an integral part of the vehicle, or shall be a separate cover for suitable material with fasteners designed to secure all sides of the cover to the vehicle, and shall be secured whenever the vehicle is transporting solid waste, or, as an alternative, the entire bodies thereof shall be enclosed with only loading hoppers exposed. No solid waste shall be transported in the loading hoppers. They shall be cleaned as often as necessary to prevent a nuisance and insect breeding, and shall be maintained in good repair. Section 5, disposal of solid waste. Section 5.1, open burning. Open burning of solid waste, hazardous waste, tires, or bulky waste is prohibited as defined by KRS 224.005 subsection 3 and KAR 63.005. Section 5.2, open dumping. Open dumping of solid waste, including bulky waste and tires, on all lands, i.e. roadsides, hollows, rivers, streams, lakes, etc., by any person is prohibited by KRS 224.835 and this ordinance. Section 5.3, disposal sites. All solid waste, including bulky waste, shall be disposed of within a sanitary landfill having a valid permit issued by the cabinet in compliance with KRS 224.830, 224.835, and 224.855 in this ordinance. Section 5.4, hazardous waste. As defined by this ordinance, hazardous waste will require special handling and shall be disposed of only in a manner authorized by state and or federal regulations. No hazardous waste defined as from a small quantity generator, or radioactive waste defined as below regulatory concern shall enter the solid waste stream intended for disposal in the county unless waste is identified to the coordinator as to its specific source, composition, and quantity. Section 6, sitting requirements. Section 6.1, license requirements. No one shall engage in business of collecting, disposing, transporting, or processing of solid waste or special waste within the county without a license secured from the governing body. In the event that any one person engages in collecting, disposing, transporting, or processing of solid waste or any other combination thereof as one operation, only one license shall be required. Section 6.2, license application. Each applicant for any such license shall provide the governing body with all information as required to provide to the Kentucky Energy and Environment Cabinet, the U.S. Environmental Protection Agency, and/or any other state or federal agency to obtain necessary permits for said operation. The following also shall be provided to the governing body if not contained in the information provided above. 1. A plan for presenting the proposal to the public, answering public questions or concerns, working with the public or the governing body to address any concerns and make modifications in the proposal if necessary to address those concerns, and for the providing public access to all pertinent and relevant information and records both prior to and during the operation of the facility. 2. Compliance with any local zoning or land use ordinances or planning. 3. Details on the exact location of the facility or service, ingress or egress to the site, any site modification required, and a transportation plan. The transportation plan shall include information on the volume of traffic to be generated by the facility or service and a statement of the impact of this service or the immediate neighborhood, the county's general traffic situation, and the condition of the roads. 4. A willingness to abide by any and all orders issued by the Martin County Department of Health. 5. A reutilization plan for the site after closure of the operation. 6. A plan for keeping the site clean and free of debris and aesthetically acceptable to the citizens of Martin County, to minimize mud, dust, and noise, and to provide a buffer with neighboring residences or businesses if necessary. 7. The proposed days and hours of operation. 8. Proof of adequate insurance or general liability purposes. 9. Any and all other information that the governing body may deem necessary to determine the consistency of the proposed operation with the goals and objectives of the county solid waste management plan and to protect the general health and welfare of Martin County and its citizens.
Okay, but
All good.
thank you.
Section 6.3, incinerators and landfills. In addition to the above information, all applicants to construct or operate an incinerator or landfill for solid or wet special waste shall provide the following. 1. Extensive and detailed information on all owners, investors, partners, operators, managers, or other key personnel, including those of companies that will provide services to the license holder, such as transportation, engineering, or other services key to the operation of the facility. That includes the following: their interest or level of investment or role in operation, past or current investment or involvement in similar or related businesses or operations, history of environmental violations, fines and citizen complaints related to each individual, as well as their past investments or involvements. Statement of qualifications for key personnel and financial statements showing the financial stability of the owners and operators in a detailed capital project budget. 2. A statement as to how the operation may affect property values within a 1-mile radius of the proposed facility or operation, as well as along all transportation routes. 3. Statement of assurance that the physical and biological environment of Kentucky's blue line streams are not adversely affected. 4. A plan for monitoring service and groundwater quality within the area potentially affected by the facility or operation, and for immediate corrective action or cessation of operation upon detection of adverse patterns or impacts upon these water resources. 5. Plans to provide resources for and to involve the general public in ongoing independent inspection and monitoring of the facility or operation. 6. Plans for making waste reduction and recycling an integral part of the operation. 7. Plans for providing resources for the long-term independent monitoring of the facility and site for a period of not less than 30 years after its closure, for a setting aside sufficient resources adequate to pay the costs of remedial or cleanup activities from a worst-case scenario. 8, a community impact statement that shall consider all reasonable community and environmental impacts, including but not limited to air and water, condition of soils, historical, archaeological, long-term land use of the site and adjacent properties, transportation, economic development, and tourism, and social impacts. 9, any and all other information that the governing body may deem necessary to determine the consistency of the proposed operation with the goals and objectives of the county solid waste management plan and protect the general health and welfare of Martin County and its citizens. All information provided to the governing body under this section shall also be made available for public inspection at a place and during hours that are convenient to the public. All technical information shall be written in such a way that it can be easily understood by the general public. Section 6.4, license issuance. An applicant must provide at least 3 copies of the above information to the governing body, along with a $500 application fee. This fee may be waived for nonprofit organizations to those engaged in recycling activities. At the same time, the applicant must provide adequate public notice that it has submitted an application to the governing body, said notice to contain a reasonable summary of the proposed operation or facility and locations and times where the above information can be inspected. Upon receipt of the application, the governing body shall begin a review process that emphasizes public participation. The governing body shall provide adequate public notice of the time, place, and purpose of the meeting at which the application shall be reviewed and shall solicit and encourage public comment on the application. Once the application is received and deemed complete, the governing body shall adhere to the following timetable for issuing or denying a license. Recycling facilities, 30 days. Convenience centers for solid waste, 60 days. Incinerators, landfills, or convenience centers for special wastes, 150 days. If the governing body is able to determine that the applicant can and will construct and/or operate the proposed facility for service without creating a nuisance or hazard to the public health or damage to the environment, in conformity with this and all related ordinances and regulations, state and federal laws, then the governing body may issue the license authorized by this ordinance. The license shall be issued for a period of 5 years, providing the license holder submits at least annually an oral or written, if requested, report to the governing body on the condition of the operation and any changes or updates in the information required above as part of the license applications process. Section 6.5, license suspension. If the Martin County Department of Health, state or federal agencies or independent inspections determine that the operation poses or is causing significant threat to public health or the environment, the operation shall cease until such situation is correct. If the operation fails to take corrective action, the governing body may revoke its license. Section 7, franchising. Section 7.1, franchise requirements. No person may engage in the business of solid waste collection unless he holds a franchise issued by the county fiscal court or its designee, authorizing him or her to collect, transport, and dispose of solid waste and describing the area for which the franchise is issued. Section 7.2, establishment of a franchise. The county shall determine the area for which a franchise is granted. Section 7.3, granting a franchise. The county shall advertise and seek proposals to serve each franchise area. Applications for franchises shall be filed with the court on forms prescribed by the coordinator. The court may grant a franchise only upon findings that the applicant will render prompt, efficient, and continuing service to the area for which the franchise is granted, and that the applicant has sufficient equipment and personnel to render service to all persons generating solid waste within the service area. A franchise shall be granted for a term of 4 years and may be renewable. No franchise shall be assignable. Section 7.4, fee approval. The fiscal court and/or its designee shall approve all fees charged by solid waste collectors. Fee schedules may be requested annually. Section 7.5, termination of franchise. A solid waste collector granted a franchise under this ordinance shall give 90 days written notice to the county before abandoning the franchise. The county may terminate or suspend all or any portion of a franchise for failure to comply with any provision of this ordinance, failure to render prompt and efficient service, or failure to comply with authorized fee schedules.
I'll do this one.
Okay.
Section 8, rules and regulations. The fiscal court and/or its designee shall make, amend, revoke, and enforce reasonable rules and regulations governing but not limited to 1. Preparation, wrapping, and drainage of garbage deposited in solid waste containers. 2. Specifications for solid waste containers, including type, composition, equipment, size, and shape thereof. 3. Identification of solid waste containers and of covers and equipment thereto appertaining, if any. 4. Weight limitations of the combined weight of solid waste containers and the contents thereof, and weight and size limitations on bundles of solid waste too large for solid waste containers. 5. Storage of solid waste in solid waste containers. 6. Sanitation, maintenance, and replacement of solid waste containers. 7. Schedules of routes for collection and transportation of solid waste. 8. Collection points for solid waste. 9. Collection, transportation, processing, and disposal of solid waste. 10. Processing facilities and fees for the use thereof. 11. Disposal facilities and fees for the use thereof. 12. Records of the quantity and type of waste received at processing and/or disposal facilities. 13. Handling of special waste such as sludges, ashes, agricultural waste, construction debris, bulky items, tires, automobiles, greases, oils, etc. Said rules and regulations, or an accurate summary thereof, shall be published 30 days prior to a hearing for public comment. After the hearing date and public comment time has elapsed, the regulations so promulgated with any amendments thereto shall be published at least once prior to their enforcement. Copies shall be made available for public inspection in the offices of the county judge executive and the county court clerk. Section 9, prohibited practices. It shall be unlawful for any person to 1. Dispose of garbage, refuse, rubbish, or debris by dumping same on any premises in the county with or without the consent of the owner of the premises. 2. Own or operate an open dump or permit the dumping of garbage, refuse, rubbish, or debris on any property within the county. 3. Deposit solid waste in any solid waste container other than his or her own without the consent of the owner of such container and or with the intent of avoiding payment of the service charge hereinafter provided for solid waste collection and disposal. 4. Fail to have solid waste collected as provided for in this ordinance. 5. Interfere in any manner with solid waste collection and transportation equipment or with solid waste collectors in the lawful performance of the duties as such, whether such equipment or collectors shall be those of the county or those of a solid waste collector operating under contract or franchise with the county. 6. Burn solid waste as defined by KRS 224.005 and Kentucky Administration Regulations 63.005, including the burning of solid waste in any dumpster or container used for solid waste collection. 7. Dispose of dead animals in any container to be collected by the county or its authorized agent. 8. Engage in the feeding of food waste to animals for commercial purposes. 9. Dispose of solid waste at any facility or location which is not approved by the county and permitted by the Kentucky Energy and Environmental Cabinet. 10. Engage in the business of collecting, transporting, processing, or disposing of solid waste within the geographic boundaries of the county without a permit, contract, or franchise agreement from the county, operate under an expired permit, or operate after a permit has been suspended or revoked, or contract or franchise agreement canceled. And 11, violate any section of this ordinance or any rule or regulation promulgated under the authority of Section 8. Section 10, service charges. Section 10.1, fees. The fiscal court or its designee shall establish or approve service charges or fees for each dwelling unit and each commercial establishment for solid waste collection and disposal as are necessary to meet all costs and operation in maintaining the solid waste management system. All such fees, including subsequent revisions thereof, shall be paid by the resident or owner on record of the property served and shall be paid to the county designee at times set by the fiscal court or its designee. Section 10.2, delinquency. All unpaid fees shall become delinquent if payment is not received within 30 days of the notice due and may result in the termination of all solid waste services until payment is received. Delinquent bills shall bear interest at 12% per annum until paid. The designee shall enforce collection of delinquent bills by bringing proper legal action against the owner or occupant of any dwelling unit or owner of any commercial establishment to recover any sums due, plus a reasonable attorney's fees, court costs, and any other costs involved in such collection action. Section 10.3, Uncollected Fees. All uncollected fees after judgment shall be placed on record in the locality where the property is located as any other judgment lien, and shall be released when paid. Section 10.4, Unoccupied Residences and Buildings. The service and service charge shall be terminated upon presentation of satisfactory proof to the coordinator that any such dwelling unit or establishment is unoccupied and shall be commenced upon renewed occupancy thereof. Section 10.5, Penalties or Damages. Any penalties levied or damages recovered under this chapter shall be in addition to any other remedies under federal, state, or local law. Section 10.6, Criminal Proceedings. Any person who violates any provision of this chapter shall be subject to criminal proceedings which can be cited by the office of the Martin County Sheriff, and upon conviction thereof shall be subject to a fine of not more than $250 if committed by a person, and not more than $500 if committed by a corporation. Each day that a violation continues after a citation has been issued or notice has been served shall be deemed a separate offense. Bless you. Section 11, Public Nuisances. Section 11.1, Notification. It shall be the duty of the coordinator to serve or cause to be served upon the owner or occupant of any premises on which there is kept or maintained any nuisance in violation of the provisions of this ordinance, and to demand the abatement of the nuisance within 7 days. Section 11.2, Noncompliance. If the person so served does not abate the nuisance within 7 days, the county may proceed to abate such nuisance, keeping an account of the expense of the abatement, and such abatement shall be charged and paid by such owner or occupant. Whenever a bill for such charge remains unpaid for 30 days after that has been rendered, the county may file a statement of lien claim against the property. Section 11.3, Penalties. Any person violating any of the provisions of this ordinance or any lawful rules or regulations promulgated pursuant thereto, upon conviction, shall be punishable by a fine of not less than $25 nor more than $500, provided that each day's violation thereof shall be a separate offense for the purpose hereof. Violators of this ordinance may be issued a citation by the county sheriff's office or any authorized police officer. Section 11.4, Cost Recovery. When the county must clean up and remove an open dump to ensure protection of the public health and safety, and when the responsible party can be identified, the coordinator shall be required these persons to reimburse the county for the actual loss incurred. Recoverable costs include, but are not limited to, costs for the site assessment, evaluation, labor, equipment, disposal, and legal fees. Should other means of collection prove ineffective, the county may seek such reimbursement of funds 90 days following the completion of the cleanup. Such cost recovery should not apply to property owners who are the victims of illegal dumping without their knowledge or beyond their reasonable control. Section 12, Bonds. Bonds are suggested to ensure the performance of the collectors or transporters of solid waste and the operators or processing or disposal facilities. The amount and types should be determined by the county. Types of bonds which should be considered are performance bonds and payment bonds. Section 13, Savings Clause. Nothing in this ordinance shall be deemed to affect, modify, amend, or repeal any provision of any ordinance administered by the Martin County Health Department or other department, board, commission, or agency of Martin County. Section 14, Severability Clause. The provisions of this ordinance are severable, and if any provision or part thereof shall be held invalid or unconstitutional or inapplicable to any person or circumstance, such invalidity, unconstitutionality, and inapplicability shall not affect or impair the remaining provisions of this ordinance.
Couple of questions on that. This ordinance shall become effective on what day? We can have our second reading. That is the first reading. The second reading can be on January the 4th of 16 at 7 p.m.
Let me inform the court too, we sent this proposed ordinance to the Division of Waste. The name of the person we've been dealing with is Lynn True for the record. We also submitted this proposed ordinance to Mr. Rich Ornstein with Keiko, is that not correct? Also, when we...
I sent other questions to Rich Ornstein.
Okay,
I have
but
not
we
yet.
notified Mr. True of the Division of Waste.
That's correct.
And we've not got a response back, but we have plenty of time to get it in case we have to amend it prior to the second reading.
So we can have the second reading on January the 4th. That's on a Monday at 7 o'clock. Now, but in this, it says the ordinance shall become effective on, do we want to make that February the 1st of 16?
It's up to the court, yes.
Does an ordinance of this magnitude require a public hearing, Keenan?
It's what you can, the court can accept. We went through this in the workshop, we discussed this, and then if you all have any comments, you can make them. That's what this is about. It affects you all. We went through this at the last, I believe Dick was here, we had comments, and we listened to people in the industry that actually is doing this. Several haulers from, was it Lawrence County? The people from Apple Valley was here. That was last week.
We didn't discuss any alternative solutions though.
But this is a proposed ordinance, this court, if you have any comments or recommendations, feel free to tell us.
You were,
And you've got another, we had a second reading back in January.
you were talking there a moment ago about having submitted this to a couple of people. So are you saying then that this plan is not yet approved?
We sent
It's not approved till we vote on it. We're not voting on this
No, it
now.
has to be approved by the state.
They will look
That's what
at
I
it,
thought.
they will make suggestions. That will be done prior to our second reading. If
Okay,
they do not
okay.
do that, Dick, we won't have a second reading. We'll come in and tell them what they told us to change.
Okay, that's,
Yes.
you answered the question.
Her name's Lynn True, if you want to contact
Yes, I
her,
think-
Division of Waste.
Lynn True, truly, and,
I can give you her number and everything and her address.
okay.
So we'll have the second reading, January the 4th, 2016 at 7 o'clock.
And it will be here, correct? Because we
It'll be
do
here.
it here every time, okay.
Now,
That will be a special meeting, Madam Clerk, and you make sure that we post everything. And
so again, going back to the ordinance shall become effective on what day? February 1st?
contingent upon approval.
Tweak it, they'll start over.
Stand on it.
February
Have you
1st?
hired somebody to actually undertake this contract? I mean,
It's going to be franchise staff. We're going to request bids like we did, try to franchise the commercial. And if you've been here last time, I believe 5 districts, did they not say you're going to provide it?
Yeah.
5 districts on the residential.
That's what was discussed, but this ordinance is silence on that.
Well, it says the county can franchise it
Can.
out.
Yeah, I mean,
And that's what they're,
doesn't express a method for that.
that's what they told us the last time, if I'm not mistaken.
Yeah,
They said you
yeah.
want to franchise
Yeah, that's what
it
they
out in 5 districts.
Can you enact it before you actually have somebody contracted to pick up
We
the
do
garbage?
the ordinance and then we try to bid it out. We did this, if you remember, we tried to the whole county and they had so many things, we didn't even get a bid. We went through this process once. I don't know if
So
you recall. We went
basically-
through- Yes, we went through this whole process once.
What we're doing is we're gonna get the ordinance, the second reading passed, and then in that same meeting, we will advertise for bids.
Had to start on your bid package.
So,
We have to
we
look on the
couldn't-
bid package because before, the bid package was for the whole county.
So we couldn't make it effective the first day of February. It had to be at least the first day of March, would you not think?
Have to
Have to have
advertise.
We have to advertise.
That's what I said, yeah.
It may, we thought before it may take 3 months, 4 months, I don't know.
June.
Yeah, we've been 2 years at it.
It's gonna get.
I'm gonna put it as March 1st.
Okay.
That'll give us 60 days. We can't get done in 60 days.
Been time for 3 years. Done it.
When you had the first reading of the 911 and the fire ordinance, was there a comment, was there a period for public comment?
Yeah. Yeah.
Between the
And you
reading,
got-
and they discussed it that night also. We had people that was here that,
I missed it, I missed it.
I still got questions about the 911 and the fire. I want to talk to you because you're.
they've already approved it. You should
Yeah,
have
but I
talked
still got
to her, okay?
questions.
But if you have any
Yeah.
questions, I don't care to answer.
Yeah, that's what, I
Does
got
anybody
questions.
not understand about the ordinance? I know it's a lot of legal stuff.
I don't, well, you know what I heard? That's what I heard. I ain't gonna lie.
This is what, we're here
Yeah.
to ask us, we gotta answer any questions.
Like the,
Basically, it's basically, we're gonna separate the districts out. We're gonna, have haulers for each district. And it's gonna be, those are gonna be the people you call. Like you'll have one in District 3,
Yeah.
that'll be the person you'll call. You can't
Yeah.
call another person if that person will have that, your area.
yeah, now I understand that, but now, what I got lost in was, like fertilizer and stuff. I have a greenhouse. You know what I'm saying? And I
If
do a
you
lot.
saw this, that's for somebody coming in making industrial fertilizer.
Okay, I'm not doing that. Okay, see, that's why, because with all
Natural
the,
decomposition.
My niece has got a thing just to.
yeah, and we burn, like, how you do, you burn your garden, on burn time, because my old time called his office, saying, hey, if we got a burn ban,
That you gotta state all of that. It's
yeah,
like the burn
see, all the
garbage,
time,
like
see, when you
plastic,
said
fuels.
burning and all this stuff, I'm thinking,
Well,
God.
that's a good
Call nobody,
question.
just burn it.
yeah. Well, I always have to call Kelly. I don't know when you can burn from 6 to 6, so they change it all the time.
That's because of the weather.
Now, I think it's a 15.
Yeah, okay.
Right.
Because I'm all the time calling, can we burn?
Yeah.
One more thing, we got changed on the 911 ordinance, the date wrong. It should read the 15th instead of the 16th.
Section C, if I'm not
Section
mistaken. I
C.
thought that on that night I discussed it. It's
I need a motion
2000.
to make that change.
Motion.
Second. All in
Kelly, for
favor?
housekeeping rules also on the 911, you need the fiscal court in section E. We have to do the resolution, you'll have to appoint that appeals board.
Yeah.
Because a lot of people's gonna come in and get a bill, tax bill, and they're gonna say that, and please bear with us because this is just starting. You may not have a building or a home that's occupied, and you can come in, present it to the court, and guess what? That will be removed. Bear with us because, it's gonna go, the tax bills, the PVA don't have the capability of saying, is this occupied or non-occupied.
Don't you have to pay it first?
Yeah, and you come in and they will take care of
Then you
it.
get your money back.
That's the,
Is that going to be on this year's?
This year, yes.
Wait a minute, when I say this year, I'm talking about calendar year 2015.
2015, yes. And if it's not occupied, you come in, that's why he's going to set a board up, he has to do that by resolution. And you show that, and guess what, we take care of it.
You can
Okay,
do that on the fire tax too, like you got.
You can opt out on the fire tax, you don't even have to do it if you don't want to.
Yeah, but how do you take it off your taxes?
You come into the sheriff, and if you opt out, you tell them you want to opt out before, when will that be started? How many days before the tax bills will even come out?
You don't need.
You won't pay on it.
Won't pay on it.
Structures on it.
he just got through saying that PVA doesn't have the capacity to segregate.
That's what I'm talking about on the 911. The 911's occupied. Occupied
Okay,
residential.
the fire assessment, the fire tax will work on dwellings and
Yes,
the,
and you can opt out, you don't have to do it. You don't even have to do
Right,
it.
but, okay, but the tax tickets, tax.
You would have to pay your tax, the $30 and then come in later, because we, we don't, Bobby Hale is not correct. He does not have that capability of
He don't
showing
know
that
who
yet.
He has the capability, but it's manual.
That's what I'm saying. We won't have it in time for the tax.
What they gonna do on the housing projects? Are they gonna be in this too?
Yeah. Dave, you have a question?
Yeah, how are you gonna propose the pricing of the trash for, like, each district? Is it gonna have the price of whatever that person that gets that district?
We will
Yeah.
set
Yeah.
bids from individuals. and
So it
then
could be different prices throughout the county?
It could very well be.
It shouldn't be.
Paul?
I got a question about opting out on fire tax. Explain that to me. I'm not
You don't
familiar.
have to do it.
You don't have to
want
pay it,
to
Paul.
and take a chance, but if you have a fire, the fire department could charge you what the state rate is, if I'm not mistaken, $500. That's them, he's on fire. But you don't have to be, you don't have to.
But isn't the fire department already receiving tax money? What's the rationale for an additional fee on top of what we're already paying?
It's
The
not- it's not an
last time I
additional
looked, the county's paying $200,000 a year for 911 and
We pay, I think
EMS.
what we pay the fire department is 80,000. That's
80,000.
what's away.
And then if that would go away, they said that's not enough, and this will supplement them.
What I still don't understand, the tax bills are gonna come out in January presumably. They'll have, and I'm not against the fire tax, but they will have a fire tax on each bill, a tax on unoccupied property, like you were talking about a moment ago, 3, 4, 5 parcels that's not occupied. And the $25 or $30 bill is gonna be on each parcel, and this is for the county.
Up to 3.
Okay, up to 3, but, and it's only for the calendar year 15 that's already, you might say, passed. So this works.
You would have to pay your tax, my understanding, bring it in proof to the fire departments. They would have, the sheriff or the fire department would have to reimburse you. Is that not correct?
We're paying a tax retroactively.
Or to opt out, they can opt out prior.
Paying tax for something we haven't got.
Yeah, that's what I was thinking.
What I see is a tax
Tax
retroactive.
someone, something you
You're
got.
talking about, how many days will they have to opt out for one of the tax bill?
they have to opt out December 31st of the prior year.
You could probably opt out before that, Dick, go tell them and show that you don't have it.
Well, I understand that, but the imposition of this tax is for calendar year 2015.
That's this year.
Which is going to be gone in a few days. The tax bill is going to come out with a tax for the year 2015. So this becomes a retroactive tax. Is that correct?
No, I don't think it does.
No,
It'd be for last year.
Yes, it's a fee.
It's
It's
a
not
fee
a
for
tax
last
at all.
year, which we're
Well, I
not.
understand the word
But
fee.
they won't have paid last
The
year.
difference between the word
This
fee
You
and
can opt
tax.
out, Dick. You don't have to do that. You can opt
I know
out.
they still don't have it.
Will the sheriff's office, whoever, will they have the administrative capacity?
So this will be
of some-
The form should be,
It will be retroactive.
Okay.
the fee
It
would.
will be. Yep.
It's not a tax, so it's a fee.
It's a fee, it's not a tax, it's not a tax.
This is not a
It's on your tax
But it
bill.
is
It's a fee.
retroactive, you will have to pay the $25.
This is not a tax, and you can't opt out. This is not a tax.
No, I know it's a fee. I understand it's a fee.
I figured
really
it's
don't have a
30.
problem. I have a little problem with some of the structure. And within, and I'm for the fire department. And I understand that. Okay, but I have a little problem with this ordinance in that it has no security purposes in there for the money. There's no bonds, no nothing. Historically, the county has given money to the fire departments. I'm not saying they're thieves, I'm not saying that. Historically, the county has given money by way of the fire departments acquiring certain equipment and sending the bill and the county paying the bill. Okay, don't have to worry about that. But there's an old saying I've read somewhere that the love of money is the root of
I
evil.
agree with you, and here's what, if you hear
But
the
I don't hear with good
ordinance, the
man.
fire
They ain't
department
got
has
an
to
equal.
provide the county with an audit.
No bond, no surety bond.
Well, it's an audit. They have to provide the county with an audit every year, They have to bring in what they spent, the checks.
The sheriff is bonded.
And the sheriff, here's the man who's gonna collect it and distribute it to them.
That's right, and there's a presumption, on my part anyway, that it's not going to be maliciously spent.
If it is.
We signed affidavits to that
You have
effect.
to answer just like
Well,
anybody else.
that's right, but there's nothing to get the money back.
Hey, Richard,
What?
officers on the fire
department.
department signed affidavits to that effect.
Basically, we're hearing what you all can do to us. I'm just gonna be honest, okay? This is what I'm getting. We're hearing what you all can do to us, but there's nothing we can do if it doesn't flourish, if it doesn't grow. Is that what you're
If the
trying
fire
to say?
department wastes the money, they
Yeah.
can be held responsible.
Who can?
The fire
The
department, the
fire
people in the fire
Personally?
department. Yes.
I agree with what he said.
I signed an affidavit stating that
Did you,
I would
each fire department
personally
sign an affidavit? They
take
would be
responsibility.
The guy, listen, he's not gonna pay the money back if I steal. Okay, he shouldn't be
You
expected
shouldn't have
to,
to
okay?
if you stole it. Why would he pay back?
If Uncle Eli gets the
want to steal
$10,000 or whatever it is, and he catches Uncle Eli, the money's gone, well, how do we get the money back?
You go after him, Dick.
It won't matter if he's in jail, he ain't paying.
Don't you trust anybody?
Yes, but listen.
That's why they make.
No, wait a minute. Now, wait a minute. Not too many years ago here, the water plant lost $1 million.
No, 3 million.
Well, did anybody get it back? Was there any surety bonds?
I ain't on the water board, I wasn't there. That's a whole different thing. We didn't know what was going on no more than you did.
All I can say is, if they don't, this man here, he sets the money up.
But
We
there's
will go after him.
no surety bond. He has a
There's
surety
nothing,
bond.
there's no surety bond, Dick, but what I'm saying is, they can be taken to court just like anybody else.
I agree with that.
They don't have one now, we're giving them 15.
No, they're not giving them cash though. They're paying for the equipment. They submit a bill and the county pays it. I'm not against the fire department.
They have a board, the fire departments have a board there. They have to, and they sign an affidavit, all the board members.
They don't
Those
submit no
board
bill
members
to us,
has
they
to
pay
submit
for
an
what we
audit
give
to
them,
us.
and then they gotta give us a budget every year.
I understand.
We don't pay their bills, the fire department's bills, they pay their own.
Right.
That's right. But when
And then if they come up short of,
That's our
like
problem.
you say, of stealing, then when they audit them, then it comes back to us, so we don't have to give them no more money. Yeah, we might have lost that money. I've lost $5 bills out here in the parking lot. I didn't get them back.
That's not what I'm talking about. Look,
You're trying to say is their assurance, can we not only put them in jail, but you want the money
I don't
back?
care about putting them in jail. I'm gonna get the money
That's
back.
what I said, that's what I'm saying. But guess what? They're entitled to court just like anybody else. First, that has to happen, Dick. Then you go through court.
I understand all that.
We may not be alive tomorrow. I don't
You're
know.
right. Maybe before the night's
But,
over. I hope everybody's
You
ready.
know, we're putting in guidelines what we're doing for this. That's all we can do. It's a fee. We're trying to subsidize fire departments who said they don't have enough money. Is that true or false? I don't
That's
know.
They
very
don't
true.
have enough money.
Okay. Well, that's what we're
They
trying to.
need more than this is
We're
going to
trying to help.
provide. I agree
And
with
if you
that.
don't want to be a part of it,
No,
in that
more than-
fee, let me tell you, you can even opt out. You know, I don't know.
This has happened before.
It may happen again, Dick, but you know, we gotta look at it when it comes. We can't guess in the future. I wish I could.
I understand what you're saying.
You know that,
I know exactly what you're
you
saying.
know, you have to go through court, Dick. You know.
I just think there ought to be a surety bond.
I like for, you know,
Even the
I like for you to have a
judge
light bulb on your head. If you lied, guess what? It'd go off, guess what? None of us be here.
Yeah.
We don't have that, so we have to
I
do
got 2
what we got.
grandkids and I see boys, they're gonna be here.
All right.
There's different bonds and different amounts. It don't cost that much bonds.
Anytime you're handling money, why not be bonded?
Well, I understand, listen, they have their own organization. They, you know, the fire department has a board.
How many fire departments do we have?
There's, 6 stations altogether. I think there's 3, that has agreements to operate. One, I thought Inez said they operated what, Tomahawk, Coldwater. If I'm not mistaken, Warfield operates Pigeon Roost.
Actually, no, we don't.
Turkey operates Turkey.
What we do,
Is that not correct?
Pigeon Roost is still its own fire department.
But you've all helped with it.
But we pay their bills, And we man the fire department,
Right.
yes. But it's still
Still
considered
there.
its own fire. We have equipment over there at that station and
Lee
everything.
told us that the last time in court, if everybody remembers.
Right.
Went through all that. Now, I say one more thing, I was gonna say before I forget, I'm getting old, but Kelly, we need to, on the 911, you need to appoint an appeals board, and we'll do that by way of resolution. And also, you need to, when it's distributed, you have to do that by executive order, we'll do that.
I got a question then.
Yes, ma'am.
Okay, I'm gonna try to keep it short, so you can explain. Okay, the 911, now I do know funds were taken out for the old 911, which we didn't have. And I got a paper saying we had to enhance 911 from the courthouse over here, saying we had it, which we did. Okay, now I don't care to pay for the new generation 911. When can they tell me it's gonna be functional? Is it gonna be up and running, or is it just gonna be on paper? And I'm not being a smart aleck.
I don't know.
I can show you. I can show you right here, it says we have an enhanced 911 right here.
This is what
Yeah,
it's
that's
called
old.
next generation, I agree.
Yeah, that's on paper, we've been paying for 911.
What's the date on
I
that?
have to, this was,
I just got that, this has been like this 4 years ago, same form. It's not-
Four
yeah.
years ago?
I don't see a date on it.
No, I just got that the other
This
day,
is not a
but
date on it.
that's not got a date on it, but it has for an
I don't
enhanced
know, do you know, Judge?
911.
I don't know. When it will be up and running.
I don't know, they
Cause see-
apply for grants and it'll take a little bit.
That's what I said, they were trying to get so much money from the federal government, and then take this and add to it so we can have the capability.
Cause see, I don't care to pay this is what I'm
Well, I
saying.
thought Mr. Gall's done a great job telling us all.
Well, I mean, I do too, when he told me, I'm not being,
I don't think nobody can tell you the date.
Really,
Yeah,
they ought to take
but
this
we're
money they're
paying.
getting this year, oh, and enhance our 911,
That's
because
what
they
I-
already got paid for last year.
They got paid $1 a month for people.
Well, they got pretty good sum of
And the
money out
county
there.
has to subsidize.
And they'll
some of
take
it.
this money and fix their 911.
We get about $4,000 to $4,600 a month.
yeah, well, see, I'm just saying, if we're gonna pay this, are we gonna get it, or is it just gonna be on paper? Get what I'm saying?
This money, let me tell you the good thing about this money too. It's put in just for 911.
And I'm not being a
The
smart.
county
I'm
can't
just
take it
curious.
out, nobody can't take it out
Hey,
for
Jenny, you
another
got a
week.
copy
Thank
of our
God.
budget?
Same way you fire.
You got a copy of our
You can't take it
budget,
out,
you've seen
so
different,
remember that.
like
the
the
county
sheriff's
can't put
budget,
that
the jail
together.
budget, our new budget
gotta help
coming in
a little bit,
July,
I don't
we'll
know.
have 911 budget.
Yeah,
And it'll show everything.
yeah, but I know what I'm saying is it showing we have it, Kelly?
They have to.
It show we have it, but we don't.
We have to have it, otherwise they can't impose this fee.
Well, it's an enhanced 911. It says right here, and we didn't have it. This is what I'm saying, it's passed, I know, and I'm not worried about that. But I wanna know if I'm paying for a new generation, are we gonna get it?
Oh, you have.
We have to. We have to.
Well, that's what I was
That's
talking
the
about
law.
this
That's
too.
the law. The state says
Well,
we
that's
have
what I
to
was talking
have
about this too, and it's on paper.
it. Yeah.
Hey, Jenny, come over next week.
I can't hear you. I've got sinus.
Come over next week, me and Leah sit down and explain to you.
Yeah, explain to me. I'm curious. I don't mean to be, I'm not being a smart aleck.
Before we
I
leave,
promise.
will
I'm
people
just-
remember my granddaughter, she's having surgery tonight.
Huh? What now?
Motion to adjourn. Second. All in there. We didn't have any, I just stick it on there every time.